Hi there. We hope you enjoyed watching part 1 of our discussion on class action suits. If you are yet to watch it, the same is available in our YouTube channel. In part 1, we discussed the types of class action suits available in India and had a guest speaker, Mr. Dhyan Chinnappa, the Additional Advocate General of Karnataka, give his insights on how the government handles class action suits. In this part, we will look into the possible advantages and disadvantages of class action suits. And towards the end, we have another guest speaker giving her insights on how third-party funding plays a role in class action suits. Now, without further ado, let's move to the discussion, and we hope you find it useful and enjoyable.
I think since we've now all touched upon what are the different kinds of class action suits or petitions or different kinds of class actions that can be filed in India, Deepak very subtly touched upon one of the advantages or disadvantages of class actions here in India, where he spoke about evidence have to be led, and it would have to be led in greater detail if it were a suit as opposed to if it were a petition under Article 32 or Article 226 of our Constitution. And I think that brings us to what are the advantages and disadvantages of class actions and how it sort of interplays between, if you have dual remedies available to you, then should you choose one over the other based on what are the pros and cons of this kind of practice?
So now that Chinmay has actually spoken about the issue of advantages and disadvantages, so I think at the outset what I feel is that I see a great advantage in the way the law has it's being dynamic than being static, because from limited common law jurisprudence of Order 1 Rule 8, it's now traveled to a position where we have clear demarcation with regard to what are the conditions. If I meet this, I will be going ahead, and if at all I don't meet it, I won't be going ahead. But for example, the Securities Action or even the Consumer Protection Act, which is 2019, which is said to be notified. So I think that way I see a lot of advantage, or I see it as a merit here to ensure that we don't get stuck at any point of time in the court, as what happened in the case which Chinmay just mentioned in UK. So I see that as a biggest advantage in the entire class action scenario.
Just to add on, when as against a jurisdiction which is more privy to class actions such as US, whereby a number of consumers or number of people come as a class and file a class action suit. In India, when you just adding on to Mahesh, when you see the law evolving stage by stage, now you are able to see statutory authorities being vested with the power of proceeding with the class action. For consider, I already mentioned that the main difference between the old Consumer and the new Consumer Act is that in the old Consumer Act, the consumers would have to gather themselves and file a class action suit. Whereas under the new Act, the statutory authority takes up the complaint as well as investigates with the help of the local authorities to derive the class action and then go forward with the case. So you can actually see the government stepping in, which will be a lesser burden for the consumers or the private people who want to file as a class action. Because any lawyer who has a reasonable knowledge in class action will say that gathering a lot of people as well as the costs involved are one of the main disadvantages in class action suits. So this will actually try to lessen the burden on the consumers if they want to file a class action.
One thing that I think has come out of the discussion is when there are constitutional remedies available like PIL, filing a petition, why would somebody really go for class actions under statutes? Because constitutional courts can literally grant you anything that they want. They have wide powers, whereas statutory bodies would be limited to what powers are given to them by the statutes. I think one thing which we need to step back and consider is, as a person, as a litigant, as somebody who's actually aggrieved, who's suffering, you will have to take a call that do you actually have an efficacious remedy under the statute or not, which is also the touchstone you'll have to prove before a constitutional court when you go there as a PIL litigant, or let's say even as a writ petition litigant under 226 before a high court. So if you had an efficacious remedy under the statute for the same remedies against the same respondents, why would you come before a constitutional court? That's a question that needs redressal, and that also needs to be thought through by the litigating parties, by the plaintiffs' counsel, before they actually approach a statutory body or a specific authority under the Constitution, which is the High Courts or the Supreme Court.
Even the courts are going to feel the same way. I mean, if there is an alternate efficacious remedy, why will you actually seek a constitutional remedy? Even the judges will process, there are more chances that they'll ask the petitioner to go before the relevant statutory authority if there is an alternate efficacious remedy.
Right, and that should be the case because our court serenity is very, very clogged. There's a reason why statutory authorities exist, including, let's say, the NGT, which is now taking up the cause for the Vizag gas leak.
I was just wondering do you think coming together as a class would ensure that the damages or the compensation that the class gets would be much higher than if it was an individual person seeking to claim something from a multi-billion-dollar company?
Agree. I mean, that's one of the advantages of class action suits. But the position in India for a very long time, I think even since Bhopal gas tragedy in 1984, is that the government has been representing classes in courts. The same, so the government or either the judiciary or the court takes suo motu matters to represent the class. And definitely, I think once class action becomes popular, it will be a much better avenue for a class of people to come together and file a suit. And in fact, you're right, you would get a bigger compensation and each individual person in the class would actually be compensated equally. So I think that's a major advantage. And I think, so from there, I would actually move into a disadvantage as well. So don't you think that class action suits could be very costly? And do you think funding would come into play over here?
Yes, most definitely. That's one of the reasons why third-party funding and class actions have seemed to develop together simultaneously, specifically in case of Australia, in case of Canada. And I'm sure that's also the case of US, that class action lawsuits. When I say class action, I'm only referring to securities class action because they genuinely have blockbuster damages. Them and third-party funding have come up together. But I don't think that's the same case with respect to consumer protection class actions or PILs for that matter, where definitely for a PIL, funding would not be the most appropriate feature to go with. Or let's say, it will be a good feature for an antitrust class action, or let's say the class action arbitration that you've mentioned, because they're commercial in nature. Anywhere where a commercial remedy or a commercial breach has happened in a relationship, that a third-party funding would not really be questionable. But where the matter comes to public interest per se, I think third-party funding may be a questionable characteristic for any lawsuit.
So having said that, I think it is the biggest disadvantage in the entire class action. It's a cost factor. So if for example, a group of people are not able to fund that particular litigation, then they have nowhere to go. Because again, the issue comes back to the deep pockets, which side has got more deep pockets and how they can fund the entire litigation. But I think, yes, costing is the biggest disadvantage in a class action. In addition to it, I also feel one more disadvantage is that having a stringent criteria without any flexibility. Like for example, the home buyers under the IBC, 10% or 100 people is a criteria without any flexibility. However, if you compare it with or juxtapose the same thing with the Companies Act, you have that leeway to seek for an exemption from that particular criteria. So I think unless until that exception or a provision is made for that exception is provided under the particular legislations, it will still be a big impediment for people if they want to pursue class action. So what could be advantages in terms of getting better compensation? can also be disadvantageous if they are not able to get together so many people or the percentage of people.
I
think
agree. And
qualification that you mentioned about getting an exemption for in terms of threshold, that's only applicable to 241, 242, which is also a class of, kind of class action, but it's not available for 245, if I'm not wrong.
Yeah, so that's what I mean to say that, there should be an exemption clause or a proviso to allow them if they're not able to meet the criteria and the claim is genuine. So and they cannot resort to, for example, if I have a grievance against a state, I can either go to civil court under for public nuisance under order 128, or I can approach the high court. But what if it's a private entity? Then how do I proceed with it? And if there's a threshold limit is quite stringent, I cannot go to any constitutional authority because I have a impediment of Article 12 of the Constitution. So that point of time, I think there should be a certain exemption clause or a reading down clause which will help people to actually initiate the actions against in the form as against class actions.
And I just want to go back to the funding part of it. There's actually one particular provision that I came across under the Companies Act, and this was Section 125, Clause 3 of the Companies Act, where the government has set up an investor education and protection fund. And what this does is that if shareholders or investors want to file a class action suit, and they want to get reimbursed for the cost that they have incurred in that class action suit. So this fund can actually provide them, well, it is said that this fund could provide them with a 75% reimbursement. Shruti, do you have any thoughts on that?
Hey, that's a very legitimate provision that you've pointed out. I think I mentioned it in the beginning, but not in such detail. I think it's not notified as such, and it's not functional so far. That's one of the reasons why class actions haven't picked up. It was talked about last year when the rules were notified, but nothing's really been said after that. So that's one part. Second is when you talk about it, we see it's called reimbursement. It's really not funding at the beginning. So that's, if you don't have the money in the beginning, how are you going to actually fund your case? How are you going to proceed with it? Reimbursement comes after certain thresholds. So the idea of third-party funding, which you rightly mentioned, is to enable and empower somebody with resources so that they can utilize their resources to pursue their legitimate legal claims. And the advantage of third-party funding would also be that it will give confidence to the statutory authorities such as NCLT or the consumer protection forums, or let's say even constitutional courts, in case the funding is permitted there, that the case is legitimate, because most of these funders do audit, conduct their own due diligence on the merits of the case. So yes, even if the specific fund exists, it will only reimburse at the later part, or a specific designated threshold after the class actually is identified as a class.
Okay. And I think we have a guest speaker as well to talk a bit more about third-party funding. Shruti will introduce us to her.
Yes, now that we've delved into third-party funding, we have a person, a senior investment manager from one of the activist funds, and which has ventured into litigation funding in Innsworth, based out of London. The guest speaker is an Indian qualified lawyer. He has been a litigator with White & Case in London for a considerable number of years. She's considered a thought leader in third-party funding by Who's Who Legal. And we're very grateful she could take out her time and join us and talk to us about third-party funding in class actions and even otherwise the process of it. So let's welcome Ms. Sindhu Sivakumar.
Thank you, Shruti. Hi, everyone.
Hi, Sindhu.
Hello.
Thank you for joining.
Thank you for having me.
What are your thoughts on class action lawsuits in India and third-party funding really bringing them up?
As far as, as far as class action lawsuits in India goes, I think it's uncharted territory. There's a lot for all your lawyers to think about in terms of how you structure such lawsuits. Is it going to be a mass tort claim? Is tort law sufficiently developed? There are statutory bases, obviously, and some of the financial, with this sort of with SEBI regulations and so on. And there's potential to use those to bring class actions. How you structure it is really sort of quite a challenge, and it's for all you smart Indian lawyers out there. As far as funding goes, it's absolutely critical. I think with any sort of group action, and they work quite different to a regular litigation where a claimant has the opportunity, brings it to a law firm. You guys work with them, see how is this a good claim, bad claim, how to bring it, and then perhaps if finances are an issue, you go and try and get funding from a third-party funder. Class actions, I think, are quite different. At least what we've seen in other jurisdictions is it's almost the other way around entirely. It's really the lawyers and the class action specialists, including Innsworth, who sort of keep an eye on the market, look at opportunities, and then work to do what we call the book build, which is actually identify the relevant claimants and bring them into the book. And once we feel that we have what we call a critical mass in order to proceed with the class action, then I think it's a question of sort of closing the book and bringing the claim. So it's just practically it's almost entirely in reverse.
Yeah, but from your sense of the market, you've seen class actions also getting developed in the UK.
Yes.
How do you see it being very different from India? I understand the laws are different. And who do you think would be a perfect, let's say, set of circumstances for India to have its first securities class action, for example?
Sure. So in the UK, right? I think it's all quite new in the UK as well. I think it's really the US that's probably the most advanced of all the jurisdictions when it comes to class actions. And that comes from a number of reasons, because it's quite easy to bring class actions in the US on an opt-out basis, which means the claimant has to specifically opt out of the class action rather than expressly opt in. Traditionally, that's always been the barrier to class actions in the UK, because claimants, the way the civil procedure works is claimants actually have to opt in. That's sort of slowly changing, which is a combination of both statute as well as judicial decisions, some of which are still going through the judicial process. There are a couple of important decisions that are pending before the Supreme Court, which will really tell us how much this type of proceeding is going to take off. So we get sort of, broadly, I think, sort of 3 or 4 big types of class actions where, funders are also very interested, and which I think of a size that would be of interest to, the big law firms and big clients in India. One is we have something called the Financial Services and Markets Authority Act, FISMA, and that's where you get your securities litigation from. So this essentially comes out of the tort of misrepresentation or fraudulent misrepresentation, basically where an issuer or a listed company has made certain statements, and in reliance on those statements, a shareholder has acquired, held on to, or sold shares and suffered a loss, then they're entitled to bring a claim and seek compensation for the losses they've suffered. That's classically where we see group actions, and it's very difficult for one lead shareholder to bring all the other shareholders together. These are disparate institutions sitting in different countries, and it really takes, I think, usually it takes a funder and a law firm to really think through the opportunity, work it up, identify the shareholders, and bring them all in, and then go with it. We still don't have a clear precedent on what's called Section 90A of FISMA, which is what is used to bring these sorts of claims against listed companies. You've got a separate basis of liability when there's a misrepresentation in a prospectus. That's a bit easier, and that's existed for a long time. The first, I think, case that's going to be coming up for trial, it was scheduled for June, and now, thanks to COVID-19, has been postponed to October, is the shareholder action against Tesco, which Innsworth is funding. There are a number of complex legal issues. Do the shareholders need to show reliance on the misstatement, a bit like the tort? How difficult is that for shareholders to provide such evidence? Does the company and certain persons with managerial responsibility, do they need to have knowledge of the fraud essentially? What are the standards? There are a number of very interesting legal questions that we'll get some clarity on once that trial goes through. The other type, I think, of class actions that are sort of brewing and is on the data privacy side. You might or might not have heard of Lloyd versus Google. That's procedurally, I think we all know what the claims are about, but procedurally it's quite interesting because they use the representative suit process in the CPR, the Civil Procedure Rules. And I think, and you can correct me if I'm wrong, that's very, very similar to the representative suit provisions you've got in the CPC. So that is definitely something, if I were an Indian law firm, I would think about seeing what the similarities are and seeing if there's some way to group things on the same basis. That's the Court of Appeal obviously ruled very favorably on that, on the procedural aspects last year, October last year, I think. That's now before the Supreme Court, and that's going to be decided in 2021. A lot of claims and a lot of, I think, funders are eagerly waiting and watching to see what happens with that, because obviously until that's decided, there's a significant risk. But that should be interesting. And I guess the third sort of big type of claims is perhaps a bit more unique to the UK, is follow-on damages claims from rulings of anti-competitive behavior at the EU level by the Commission, and that comes from statute, and that's again quite statutory, but that statute is of particular interest to funders and for lawyers wanting to bring class action claims, because that allows you to bring class actions on an opt-out basis, similar to the US. And so you get around all the obstacles of opt-in class action via the CPR. So that I think is that's booming. That's going to be affected sadly by Brexit. We still, so everyone sort of, there's almost there's a sort of urgency with which law firms and funders are looking to bring eligible claims before it's potentially too late. We don't know. It all depends on how Brexit goes. So that's, I think, I suppose broadly the three big types of class actions that at least in the commercial litigation world we're seeing. I don't know. I mean, you can. I would be interested to hear from you actually as to what sort of similarities you see in terms of what's statutory provisions in India. Either SEBI regulations or even the CPC and the representative suit process.
Yes, like you rightly said, representative suit in our CPC is very similar. But I think the bottom line which we see, which is different between the US, UK or India, is the lack of blockbuster damages. So probably the third-party funders would be more interested in Indian lawsuits, specifically class action lawsuits, if a lot of, let's say, a critical mass collects, and in the end we have a big blockbuster damage claim, from which a part of it could also be used by the third-party funder.
Absolutely. But procedurally, there are sort of, it sounds like there are sort of clear routes to bring similar types of action.
Now, class actions that exist in India are very different, which we've covered in the earlier part of our discussion. But just to give you a brief background, it's different. For example, consumer class actions, they're statutory under a specific statute in India. They're also opt-in, not opt-out. Then you have CPC suits, which are similar to your lawsuits. Then the third would be securities class actions. That's under the Companies Act. It's a relatively new provision. It came out in 2013, was notified in 2016. We had rules enforcing it last year in 2019. But so far, nobody has actually filed a case for securities class action. I personally have drafted these petitions, but it never went through because there's clear lack of clarity on how the law would operate. And these as well are opt-in and not opt-out. So these are three major commercial class actions. We also have provisions for anti-suit class actions, but nobody's really sued under those provisions. Then we have something called public interest litigations, which is very similar to sales in the US. But again, no blockbuster damages. They're usually against the government for either compensation or specific mandamus or directing the government to do or not do certain acts. Besides that, we also have small class actions under different legislations like real estate legislation. And I think Deepak and Mahesh are very, very well placed to talk about it. They're hardcore litigators. Besides that, at the end of our discussion, we realized the lack of blockbuster damages is one of the reasons why TPF is probably not burgeoned in India.
And is that just to do with getting a sufficient book of claimants, or is it just the sort of legal principles the court is following when it's awarding damages and the way it's interpreting those principles that you see being the issue?
We think it's both, primarily because of lack of clarity on law. That also encourages a lot of litigants, specifically serious litigants, to take up these claims.
And yeah, it's interesting you say that we have a very similar experience, or we've had in the past with the FISMA securities claims, because it's all novel law and it's quite complex stuff. There's a lot of points, like some of which I mentioned just now, that need to be interpreted and we need some judicial clarity on, because they sort of come out of a tort we all know, but they're statutory and there are differences in the way they've been drafted, and we need some judicial clarity on how it's to be interpreted. That obviously makes it, again, quite difficult, I think, for one loss holder or one shareholder to take the charge and go through a long litigation process and sort of bear the cost of bringing this clarity. But obviously, I think when you have funding and when you have a law firm and a funder that's bringing it, there's a lot less risk for the claimant. Yes, the claimant has to participate, obviously. You still need to provide the witnesses' statements. You still need to sort of do disclosure and cooperate in it and sort of overall be quite involved in the litigation. But financially, there's very little risk, if at all. I mean, basically no risk to you. And I don't know if it's helpful to just go over how funding works a little bit, or
please go for it.
Sure. So basically, with third-party funding, a funder such as ourselves would provide what's called non-recourse funding for the claims, which means we'd enter into a funding agreement with the claimant saying, if you fail, we get nothing. The risk is on us. The litigation risk is on us. But if you win, we will recover our costs, the costs of running this project from start to finish, and we will also take a percentage of the damages that you win. So what's typically called a commission. For a claimant, that's fantastic, because if you think about how long a litigation goes on for, and particularly these kinds of novel law litigation, they will go on for a while, and there may be appeals and further appeals. It's highly likely. So that's years and years of taking a hit to your P&L account, your profit and loss account, because that's every month your lawyers are going to issue an invoice to you. That's going to come off your P&L account, but you obviously can't record your. You can't record a contingent asset on your account, so you can't provide for the claim in a positive manner in your books. So that's just years and years of taking a hit to your P&L account. Whereas with litigation funding, the funder pays the lawyers directly. As far as the claimant goes, yes, you're involved, and there's the usual what we call the opportunity cost of bringing any litigation, because you've got to devote time and resources to, I don't know, preparing witness statements that you could have been doing to do your business and actually make money. But apart from that, you've taken the hit to your P&L out completely. And if, yes, you sacrifice a little bit of your sort of winnings or your damages in the end, but particularly in such a long-running and risky kind of litigation, it's been our experiences that GCs think it's more than worth it.
Yes, of course. You've anyways made up for the lost amount, if we call it that, for the time that you saved.
Yes.
Sindhu, just picking up from what you've said, may I ask what kind of criteria would a third-party funder look at before deciding to actually fund litigation, particularly a class action litigation?
Sure. In some ways, it's quite similar, I think, a class action to sort of any other kind of proposed litigation. So we would obviously look at the merits, and with a class action, typically it's less. It depends, obviously, but I'm just thinking of a securities action. The issues tend to be less factually complicated, but more legally complicated. So you get yourself comfortable on which way the court is going to likely interpret the statute, get yourself comfortable with all that. You will obviously look at damages, and you would look at the type of damages that you're going to be entitled to. And you would sort of put all that together, and then I think you almost go the other way. You say, you say this needs to be my target in terms of the book build, in terms of the value of the claim, and it's at this time that it becomes viable. And you and the law firm see if that's possible, and you go about sort of trying to get that value of build a viable book. And I suppose sort of just, I mean, that's slightly simplistic, but going into both merits and going into damages and so on it's context specific, it's jurisdiction specific. You have to look at the courts, how they're likely to deal with such things. You also got to think a little bit about, I suppose, evidence and the claimants. So I mean, if you're going to have claimants who decide subsequently that they're not going to participate or provide factual evidence, that's a problem. That's also something I think a law firm looking to build a class action would consider. And other than that, in some ways, if you think about it, enforcement is actually much easier because you're going up against big listed companies. It's in many ways it's significantly like less of an issue than in, say, a BIT arbitration or something like that.
Thank you. This was good. I'll just ask Deepak, Mahesh, and Madhav in case they have any questions about third-party funding that they think audience is interested in and we haven't covered it.
Yes,
I just had one.
Go ahead, Mahesh.
Yes, I just had one question taking off
Sure.
from Chinmay question. If you have any documentation with the claimants so that they don't leave the entire process midway, which might defeat the entire process of class action if the class action is dependent on the number.
I mean, you would flag it to them, and it's something that you would want to make sure those who sign up are sort of fully on board.
Mm-hmm.
It's not uncommon as well to see provisions in funding agreements that say, if you leave a particular group and you go and join another group, there's some sort of penalty. That's it, really.
Ideally, you would audit the provisions of certain processes that class action lawsuits take into a specific statute or a country to figure out how you're going to maneuver through it.
I think that's probably right.
Okay. Deepak and Madhav? Madhav's raising his hand, but we can't hear you. You're on mute.
Again on mute. Oh, I'm so sorry. Okay. No, I just wanted to ask. So, as a third-party funder, you look into the merits of the case before you even think of funding it. In a class action suit, however, you have different claimants. So then, do you actually do due diligence for each claimant in a class action suit, or would you just go to a class representative to do so?
When you say due diligence on a claimant, do you mean the sort of do you due diligence each person?
So basically, yes, the claim. So you would have to look into whether they have valid evidence to actually succeed, because would that be a problem for class action, or would you have to be quite tedious?
It's quite a good question, and I think it's anytime you've got a legal basis for a class action that involves factual evidence, frankly, that's something a funder and a law firm should be thinking of, right? You don't want to sort of build a book of 100 million only to have 80 million drop away because they don't have the requisite evidence. How do you do that? How do you do that when you go out to the market? You come up with some sort of a questionnaire. How do you weed them out? Is I think a logistical challenge, but it almost depends on the law. If you've got a basis for claiming compensation that is not factually complicated. So, for example, you've got in the UK, you've got a prospectus claim, for misstatements in the prospectus by a company that does not require claimants to show any reliance on those misstatements. Now, that's sort of the question is moot, right? It's not an issue. So there would be no need to think about that. But if we have a situation where factual evidence is important, then I would think it's prudent to ask claimants, make sure the claimants are sort of able to send witnesses on the day of the trial, able to provide witness statements, etc. Before we're well underway.
Just one last question, Sindhu. I know you have these definite set of procedures for which you do due diligence based on your already existing experience in different jurisdictions. But since in India, class actions are more in the uncharted territory, it's still evolving. How do you actually go about it? For example, consider Companies Act Section 245 was the classes were notified only last year in 2019. And Consumer Protection Act, even though class actions were there in Consumer Protection Act, it became more comprehensive only when the new act came in last year. So there are various new rules and regulations which are coming up. And how do you actually go about it? I mean, how do you do your due diligence to see actually the legal aspects of it?
We would work with you guys. We would work with smart Indian lawyers to sort of analyze the provisions with us. Look at it. Tell us about their experience with the particular courts and the particular judges we're thinking of going before. Any similar sort of previous law that we can look at to sort of get a feel for how the interpretation is going to go. But I think very, very similar, honestly, to how you guys would look at it from a legal perspective.
Amma, what are your three main requirements if you ever want to invest in a class action lawsuit in India as a third party funder?
In some ways, you guys telling us that, look, the statute, this is a great statute. We actually this is a great claim, and we don't see why this would be interpreted in any other manner than the way we think we do. So that, I guess, legal merits, let's call it. The company we're going before, are they nearing insolvency? Do they have enough market cap in order to be able to pay the big amount of damages that we may be claiming? And more practically, I suppose, also, what's the strategy in terms of bringing all these loss holders together? That is something we would want sort of to know or to understand what's feasible and what's not. If, for example, you tell us all this is great, but actually in India, no one's going to sign up for it because, I don't know, for historic reasons, so they just don't like novel law claims, whatever it might be. That's also an issue. So yeah, off the cuff, I would say these are three things I would think about.
Thank you. That was very informative, and thank you for your time.
Not at all.
Welcome.
Yeah, thank you so much.
Thank you for having me.
Sindhu, and sharing your inputs.